Good morning, everyone. My name is Jack McDougall, and I'm the President and CEO of the Board of Trade. I want to thank you all for joining us today, and I hope everyone's staying safe and adjusting to this new, rapidly changing world that we live in. Certainly, nobody really saw all these different effects coming our way, both with the pandemic and public health issues, and then certainly the economic hardships and fallout. Really challenging to try to wrap your head around all these different things. And I'm sure, like most of you, I'm at home working and staying safe, and so hopefully that's what everyone else is doing too. We started hosting these briefing calls about 3 weeks ago, and we're now starting to get into more of a routine on them, and we'll be having many more over the next few weeks on specific topics of interest that our members and others have been bringing to our attention. I know there's a lot of sort of higher level strategic conversations, but we really saw value in bringing together some people with some really deep expertise to help us get better tools in order to navigate the road ahead more effectively. Tomorrow we'll have a team from K&L Gates. They're going to go through in detail the recently passed stimulus CARES Act. So I would encourage you to join in on that. And today we're really excited to have Betsy Lewis with us. She's from Cooley. She's going to do a deep dive into what employers need to know in navigating through the COVID-19 crisis. And we really do appreciate her sharing her perspectives. And, against this backdrop, thinking about now, how do we do all these things in a virtual environment? So that's a bit unique, I think, for many of us. Just very quickly about Betsy, her practice focuses on labor and employment law, civil rights law, and litigation. In her practice, she works with clients on cost-effective business solutions around a whole host of employment problems and challenges. She works on issues from compliance with employment laws, managing difficult employees, developing and implementing personnel practices, procedures, due diligence for IPOs, mergers and acquisitions, compensation packages, employment and non-compete agreements, discrimination complaints, and so many other things. And again, how do we do this now with virtual teams, working with, difficult employees, and, how do you manage some of these processes? So very much looking forward to this conversation. If you have any questions, please send them in through chat, and we'll try to get to those as we go forward as well. And so with that, let me turn it over to Betsy. And Betsy, thank you so much for joining us today.
Thank you, Jack, and it's my pleasure. So we're going to dive into some of the issues for employers. There are going to be aspects of your business that are going to be outside the scope of this presentation. I will try to cover as much as I can that relates to actually managing the employment process within a company. And if you have questions, you can submit them via the chat function. Jessica Shahadi from the Board of Trade will interrupt me if it's something that she thinks needs to be answered in the context of the presentation. Otherwise, if we have time at the end, we'll get to some more of your questions. So we're going to start with talking about, kind of operational issues. So the first question that many businesses have is, okay, who is an essential person to our business? And what is an essential function? And the first thing you're going to want to do is determine that from a business perspective. And then you're going to want to check it against the executive orders in your jurisdiction to make sure that how you are planning to operate works within the context of what that jurisdiction's order requires. And as many of you know, that's a changing landscape on almost a daily basis. So note that there's no way to understand this except on a case-by-case basis. There's no broad rule that we can apply here. We've got to look specifically at who's an essential person and why, and how that fits into the executive order. So I can't answer questions about, is this person essential or is that person essential on this call, but merely to say, you've got to first determine what is essential from your business perspective, and then compare that to what the executive order says. If people are essential, then we have to ask the question of what OSHA's general duty clause requires in terms of providing a safe workplace for those people. So some businesses have specific OSHA requirements that apply to them. For example, in healthcare, you have to comply with OSHA's regulations that regulate bloodborne pathogens. We're not going to get into specific OSHA rules for specific businesses here. We're simply going to talk about the idea of providing a clean workspace. So first of all, the place where you're asking people to work, if it is your facility, needs to be clean. If they're working in your facility and it's clean, you might still want to require them to wear a mask and gloves. And certainly if they're going into other people's facilities, homes, etc., you want to require a mask and gloves to make sure that they are protected. And sometimes it's hard to get masks and gloves, but I think it's something that you want to think about in terms of the safety of your workforce. And you also want to provide for social distancing. So if people are needing to come into your office, you want to make sure that there are not too many of them in a small space and that there are not too many of them at the same time. So what if an employee is someone you consider essential and you need to have that person working and they refuse to work? They say, I don't think this is safe, I don't want to work. So the first thing to do is to talk to the employee about what might change that, what you could do to make the workplace more safe. If they still are refusing to work, then you want to consider what leave is available to them on a paid basis that they can take. And then if they still don't want to work, then I think you want to consider unpaid leave for them. I would be hesitant to terminate somebody under those circumstances. I think it's better to put them on unpaid leave until they're willing to return to work. In extreme circumstances, you may find that you have to let the person go because it's an absolutely essential function and you've got to have somebody else doing it. But hopefully those are few and far between. So what if an employee who is working for you gets the virus and comes to you and says, I think I caught this virus because you made me work or because I've been working? So the first thing you want to do is tell that person that they can file a workers' compensation claim, because workers' compensation claim is the way that workplace injuries are taken care of, and you have paid insurance to participate in that program. Most workers' comp carriers are denying claims unless it's for healthcare workers on the basis that people can catch this virus anywhere and the person did not catch it at work. But in any event, your job is simply to provide the employee with the opportunity to apply for workers' comp. You do not adjudicate whether they're eligible or not. So is there any circumstance under which workers' comp would not apply? In every jurisdiction, if the employer has taken action to create an absolutely ridiculously unsafe condition, then it might come outside the scope of workers' compensation. Also, if you violate OSHA regulations, you could be subject to fines and penalties by OSHA. But so long as you're doing your very best to provide a safe workplace and following the protocols that you have at your disposal, then the chances of that happening are fairly slim. So let me stop there. Jessica, were there any questions about that?
No, there are no questions in the chat box at this time.
Okay, so let's move on to what can an employer communicate about an employee who is ill, who is exposed to the virus and quarantining, or who is known to have the virus. So the first rule is that you can communicate anonymously with people who may have potentially been exposed, and you can communicate specifically, again on an anonymous basis, to people who you think are particularly at risk for having been exposed. If you get the permission of the individual, you can communicate who is involved here, but without that person's permission, you should not name names, except I think in a very extreme circumstances where you are faced with a condition where you think it is a life or death matter and you think it is important to communicate the person's name, which I think will be few and far between, then you should consider prioritizing safety over privacy. But in that circumstance, you should seek counsel before you make that decision, because privacy laws are different from one jurisdiction to another. And you want to make sure, first of all, that you really think it's an extreme enough circumstance that you might have to prioritize safety over privacy, and then you still want to talk to a lawyer before you would move forward. So now I'm going to shift to remote work. So the first thing you need to think about is how you can facilitate remote work for people. And I think it's important not to be stingy here about what someone needs. The notion of making an employee set up their own home office in order to work remotely is probably not reasonable under the circumstances. And we've had requests for standing desks and for special equipment of various kinds by employees of some of our clients. And for the most part, you want to try to comply with those. There is an argument that if the employee already has a home office that they're using for personal purposes and they need a standing desk for their own use, then the employer shouldn't have to provide it. But given the circumstances here, it's probably best to err on the side of providing whatever equipment they're asking for. The other question that comes up fairly regularly is, I have some employees who are great workers and I would be happy to have them work remotely. But there are other employees who I don't trust or who aren't very good workers, and I think it might be a problem to have those people working remotely. I think the best thing to do here is not at the outset make a distinction between good employees and bad employees, particularly if there's not pretty good evidence in writing that's been communicated to the employee about the fact that they're not performing well. I mean, if you have someone who's already on a performance improvement plan or otherwise in a disciplinary or performance management program, then possibly that is a person you say can't work at home. But for the most part, the way you want to manage this difference between good employees and bad employees is to set very clear guidelines for what's expected of the employees. So what metrics are expected? What performance, what production is expected? What communication is expected? When are they expected to be online and available for questions and answers? And then hold people's feet to the fire in terms of meeting those standards, so that you have a rational basis for telling people, you know what, we gave you the right to work remotely, but your work is coming in late, it's not properly finished, you're not available for questions and answers. So, you know, we've decided that we can't continue to employ you in this way. That way you have a basis for making the decision other than just an arbitrary line in the sand at the beginning. So, speaking of work hours and being available, one of the things that I would encourage you to do is to be flexible with respect to work hours. If somebody can get their work done well by working off hours because they're trying to juggle childcare, I would definitely consider letting them do that, because they will be more productive if they can work when it suits them. Now, there's some people who are answering customer inquiries who have to work when the customers are calling. And so you have to think about what the person's function is and whether it really allows itself to flexible hours. But I think to the extent to which you can allow flexible hours is going to be very helpful. And that my final thing that I wanted to note about remote employees is communicate, communicate, communicate. The more you stay in touch with people, the more you check in with them about work, about their personal lives, the more you connect people during this time, the better off your workforce will be and the more productive. So let me stop there again. Jessica, are there any questions?
No submitted questions at this time.
Thank you. Okay, the next topic I wanted to cover is salary reductions. So if you are thinking about reducing salaries, the first thing you want to do is check offer letters and contracts to see if there are any restrictions on your ability to do that. So in some executive agreements, if you reduce someone's salary without their permission, they can quit and get a certain amount of severance pay because you've reduced their salary. If the employee is at will, and the employee says, my offer letter says my salary is $350,000 a year, you can't reduce it because we have an agreement in our offer letter that that's my salary. First of all, the offer letter, if it's countersigned, is in fact a contract, and it is potentially enforceable. However, most of these offer letters say that the employee is employed at will. And so a good question to ask the employee is, would you rather be terminated? And an option could be to terminate the employee. You could then offer them a job again at a reduced salary. But most people faced with that choice will agree to the reduced salary. So hopefully you can work with people to agree that reducing salaries is a better option than having some people laid off. And it could be you if we don't have a salary reduction. You also want to be fair. Everyone should be included in a salary reduction, except possibly very low paid workers who either are already at a minimum wage or are so close to the minimum wage that it really doesn't make sense to reduce their pay. And you want to make sure that executives are included. You will create lots of ill will if you reduce salaries, but do not do so for the executives in the company. Many companies who are going through salary reductions right now are doing percentage reductions based on what tier within the company people are. So people at the highest level are taking a higher percentage reduction than people at the lowest level, and there's one or more layers in between. You do not want to promise that you will make up the difference at some point in time. For one thing, the law doesn't allow you to defer salary because the laws in Virginia, Maryland, and the District of Columbia and other jurisdictions as well require that wage payments be made on a certain schedule. So you can't say we won't pay you your wages until September. You can reduce their wages. If you want to, at some point, make them whole, if you can, then you want to tell them that it's contingent. So if it's contingent, it's not a deferral. It says that if we can pay you, we will. But you don't want to refer to it as salary. You want to make it a bonus. And then pay people bonuses to make them whole for loss of income at such time as you're able to do that. But again, probably in this economy, not even promising that you might be able to do that, may be your best bet. If you really think that you kind of understand your business well enough to know that at some point in time you're going to be up and running again and you're going to be able to repay them, then that's fine. But otherwise, you should be careful about making such a promise.
Betsy, we do have a few questions through the chat.
Okay, and can you, are they on this topic?
They're requesting FLMA, a question about FLMA, and then workers asking out of state working remotely.
So what was the acronym? Is it the FLSA or the FMLA?
FLMA.
I think they mean the Family and Medical Leave Act, FMLA. We're going to talk about the new paid leave law, but that's a separate topic, so we'll get to that, and we'll talk about how that works with the Family and Medical Leave Act as well. But let's table that for now, because that's a separate topic that we're going to talk about.
Wonderful.
And what was the second one?
Should we accommodate out-of-state work remotely requests?
That is a business decision. So there's no reason not to accommodate those requests if it's possible for that to work for you. So again, you want to think about whether the person can effectively perform their job remotely. If my suggestion is that if you're allowing local people to work remotely, there's absolutely no reason not to allow a person out of state to work remotely, because there's really no difference right now between a person in Maryland, Virginia, or the District of Columbia working remotely and a person in Oregon working remotely. So I would consider that a business decision first and foremost. There's no reason not to do it. But if you've got a good reason why it doesn't work for you, because the nature of the person's job doesn't allow it to be done remotely, then you can say no to that request. Okay, so we've talked about reductions in salary. They may or may not be accompanied by reduced hours. So what are your obligations in terms of paying people? You must pay people the minimum wage, which varies by jurisdiction, for all hours worked. So if you needed to reduce salaries below a certain level, the only way for certain people to have less pay is for them to have less hours. And you may decide that based on your business needs, you need less hours from other folks as well. For exempt employees who are paid on a salary basis, the minimum salary under federal law is $35,568 in 2020. It is higher in some states. An exempt employee can accept that amount or a higher amount if they've already been paid that much money as their full compensation for the year. You can also bring them up to that level and have them accept that number as their full compensation for the year. But if that tool doesn't work for you in terms of managing an executive's pay, let's just say you want to make sure that the executive makes a little bit more money than that, but not necessarily a lot, then you can take an exempt employee and put them on an hourly basis. So long as they do not work overtime, then you can manage their pay. And that would be on an emergency basis for this pandemic response, with the notion that they would go back to their old salary basis afterwards. If someone is marginal in terms of whether they're exempt or non-exempt, then there's some risk in doing that, because the suggestion is that they should have been non-exempt to begin with. But so long as a person is in a position that's clearly an exempt role, and you are doing this on an emergency basis, then it should work fine for you. So those are some of the tools that you have at your disposal to manage pay. Some of you submitted questions about unemployment, including unemployment for part-time employees. Unemployment is pretty much beyond the scope of what we can discuss on this call. Unemployment is complex, and the rules vary from one jurisdiction to another. In some jurisdictions, very low-paid part-time workers are eligible to receive unemployment benefits. But unemployment is not a tool that you can use to manage your cash flow at your business. Unemployment is there for people under extremely difficult circumstances. And while some part-time employees might potentially qualify in some jurisdictions, it is not something an employer should be thinking of as a way to conserve costs. Some of you also raised questions about the PPP loans under the new CARES Act. PPP stands for Paycheck Protection Program. And the program tomorrow that KNL Gates is doing on CARES will cover that topic of those PPP loans. That is outside the scope of this presentation, but Jessica, do you want to tell people how they can access that program tomorrow?
Sure. Tomorrow's conference call will be available at 10 a.m. It's 10 a.m. to 10:45. And if you'd like call-in details, email events@bot.org.
Thank you. So any additional questions?
There are no questions in the chat box.
Thank you. So we're now going to move to talking about furloughs and layoffs and terminations. So the terminology here is confusing because the word layoff is used sometimes to refer to a furlough, which is a temporary non-working status for people who are otherwise employees. And sometimes it's used to refer to a termination for lack of work. On this call, we're going to use the term furlough to mean a temporary lack of work. And we're going to use the term layoff to mean termination for lack of work. So how are the two different? A furlough has the same effect as termination with two exceptions. The first is the message to the employee is, we want you back and we will bring you back when we reopen or rebuild our business. That does not mean that you cannot have a qualifier in a furlough letter that says, we right now expect to bring you back, and here's when we expect to bring you back. But you need to know that we may need to terminate you at some point in time, and we may need to extend this furlough, or we may need to call you back early. But when you terminate someone, you're telling them, we're not going to call you back to work. And the only way that person could ever possibly be rehired would be to apply for an open position and be hired for that position in the future. But otherwise, you're not staying in touch with those people in terms of returning to work. Furloughed employees, like terminated employees, are eligible for unemployment compensation because they are not working. They also may have a different treatment in terms of staying in benefit plans. Some employers are not aware of the fact that it is not a choice to keep people in benefit plans. Your benefit plans, and we're going to talk primarily about healthcare plans, are contracts, meaning that it is a contract between the employer and the insurance carrier with respect to providing those benefits. A person who does not meet the definition of active employee under your health plan cannot be kept in benefits. And in fact, if you pretend to keep them in benefits and they're not an active employee under the plan, then they have no coverage. So what you want to do is find out how long you're able to keep furloughed employees in your benefit plans. Some carriers now are agreeing to allow furloughed employees to stay in the health plan for the duration of the furlough under this new COVID-19 pandemic response situation that we're in. But you've got to know what your plan provides. Now, a person who is furloughed, who can't stay in the benefit plans, it still should be eligible for continuation coverage under COBRA, which is the federal law which applies to employers with 20 or more employees, or under state or local continuation coverage. So if they elect continuation coverage and you want to treat them as you would have treated them if they had stayed in your plan as an employee, then an employer can choose to pay the premium or a portion of the premium for furloughed employees. So as a practical matter, so long as the furlough doesn't last longer than the COBRA coverage period, those people will still have their benefits on the same basis that they had them before. It is very important not to promise reinstatement to furloughed employees because you don't know what's going to happen. And so you want to make it clear that if circumstances change, that they may be called back early, their furlough may be extended, or they may be terminated. Many times I get a question about whether an employer can ask an employee to sign a release of claims when they go on furlough or when they're terminated. In order for a release of claims to be effective, it has to be part of a contract. A gratuitous promise to release you is not enforceable as a contract. So you have to offer them something of value that they're not otherwise entitled to in order to ask them to sign a release. Many employers right now are not asking furloughed employees to sign a release. They're not providing pay or other benefits in order to ask for a release. Some of them are willing to, at some point, pay the furloughed employee something, but they're concerned that they might have to terminate them, and they want to save that benefit to pay them if they have to terminate them. But again, you can make a severance payment to a furloughed employee and have them sign a release, and you can do that with a terminated employee as well. Some employers are doing neither right now. They're simply not asking for a release of claims because of the dire circumstances that they think they are in. Let me pause there again, Jessica, and see if there are any questions.
There are no additional questions submitted.
Thank you. So now I want to focus our attention on the Federal WARN Act, which is the Worker Adjustment, Retraining, and Notification Act. This is the law that requires 60 days notice of a termination. So WARN applies to employers with 100 or more employees. And employees who work less than 20 hours a week are not counted when you're trying to figure out if you have 100 employees. They're also not counted in trying to figure out if WARN applies to the decision. So WARN applies to plant closings and mass layoffs. A plant closing is a full shutdown of a single site of employment or a discrete business unit of the employer that affects 50 or more employees. So there's no amalgamation of different business units, that there's no amalgamation of places of employment. WARN also applies to a mass layoff. A mass layoff is a termination of employment that is not a plant closing that affects 50 people and 33% of the workforce at a single site of employment or within a discrete business unit. You must look back 90 days and forward 90 days to just see who would be included in that. Someone who was terminated for performance 60 days ago is not included. It's people who were let go as part of a reduction in force. There are exceptions to WARN. One of them is called the faltering company exception, where a company is trying to stay afloat and is trying to get financing or get contracts or do something else. And if they told people that they were being laid off, it would keep them from getting the financing. That particular exception only applies to plant closings. There's a second exception called the unforeseen business circumstances exception. And at the very beginning of this crisis with the coronavirus, that was a very viable reason to not give notice for businesses. As time goes by, the circumstances are less unforeseeable. So you want to think about it not being unforeseeable unless it's done quite quickly, or unless there's an intervening cause, such as an executive order that absolutely forbids your business to run. There's another exception called the natural disaster exception. It is unclear whether that applies to this virus. It was put in place to cover hurricanes and floods and the like, but some people are looking to use it to avoid having to give notice under WARN. Finally, there is the furlough exception. So a furlough of less than 6 months, that employee who is furloughed is not counted as a terminated employee for WARN purposes. And that is a quite viable tool right now, because most of us think that this virus is not going to keep people out of work for 6 months. So if you have a furlough return date that's within 6 months of the date that you furlough someone, and you have a valid reason to believe that the furlough will not last longer than that, then you fit within the furlough exception to WARN, and you're not going to have to give notice to that person of 60 days before furloughing them. Now, if you want to end the furlough, if you want to extend the furlough or terminate the individual, then you need changed circumstances in order to support that decision. But in this environment, that's quite possible that that would happen, that there would be something that would occur that would change your mind. So I was talking yesterday, to a business that supports schools, and they're furloughing employees, but with the understanding that school will be open in the fall. And for the most part, we think that that's probably true, that this virus will not keep schools closed come August or September. So they're doing a furlough with the understanding that they'll bring their employees back when businesses reopen. So let me stop there and see if there are any questions.
No additional submitted questions.
Okay, so the next topic I want to talk about is this new temporary expansion of the Family and Medical Leave Act. Some people asked about regulations under this law. I'm not anticipating regulations because this law sunsets in December 31st, 2020. But there is guidance on the DOL's website in a Q&A form, and I think that's what you want to use as regulations for now. And probably that's all we're going to get. There's also a poster to notify your employees that's posted on the DOL's website. So those are the two places to go for guidance about how this thing applies. So the first bucket is emergency sick leave, and that applies in 6 different circumstances. The first 3 relate to the individual's health and condition, and the last ones relate to caring for someone else. The final one is experiencing any other substantial similar condition specified by the Secretary of Health and Human Services in consultation with the Secretary of Treasury and the Secretary of Labor. Until there's something that's ruled on by those agencies, you don't have to worry about number 6. So if the reason for the leave is the employee's health, which is that they're subject to an isolation order, they're subject to a self-quarantine order, or they have symptoms of COVID-19, then they get paid for up to 80 hours of leave at $511 a day. That's the maximum pay under the law. If you pay more than that, that is fine, but you will not get reimbursed for it. So you actually get a tax credit for these payments. When you submit your payroll taxes, you take a tax credit against the amount of your payroll taxes. If that doesn't cover it, Treasury will write you a check. So this leave is meant to be at no cost to you. If the reason for the leave is to care for another person, it's $200 a day maximum. The 80 hours is prorated for people who work less than 40 hours a week, and it is not extended for people who work more than that. So the maximum is a total of 80 hours paid, and that could be 50 hours one week and 30 another, but the maximum is 80 hours, and it would be less than that for people who don't work a 40-hour work week. There is also a separate portion of the law that provides 12 weeks of childcare leave, and it applies to someone who's caring for a child because of closed schools, daycare, or the unavailability of a caregiver. That is $200 a day. The first 2 weeks of it are unpaid, but you can use either the employer's paid leave or the 80 hours that I just mentioned to cover that initial 2-week period. After that, it is $200 a day for up to 12 weeks of leave. And that can be used on an intermittent basis in order to allow someone to switch off childcare with a spouse or some other reason. There is a lot of detail about this law in terms of how it might protect you. So one thing to know, though, is someone who is furloughed and who you do not need to work or you're about to furlough is not eligible for this leave. And you have to certify to the government that the person is eligible in order to get this tax credit. So you don't want to tell somebody, well, I was going to furlough you, but I'll let you take the leave and I'll furlough you at the end of that. I think the government will think that they shouldn't be paying the employee at all. So you're going to want to be careful with that. So I'm going to stop there. We have about 5 more minutes if people have questions.
Feel free to submit questions via the chat on the right-hand side of your screen. I don't see any new, oh, okay. Let me see. No new questions at this time.
Okay. It is almost 10:45, so if there are no further questions, I think we'll wrap here. I mean, 11:45, sorry.
I'm sorry. We have a question that just came in.
Okay.
What are immediate next steps for exploring pay decrease with employer?
I'm not sure I understand the question. Is that a question from an employer?
Some employers are not even aware of this option. This is coming from AECOM Arlington.
Okay, so, I mean, it is a business option that employers can explore. So what you want to do is start by looking at offer letters and contracts, and then put a plan in place for salary reductions. What I have experienced so far is that people are very willing to accept salary reductions over being terminated in this economy. But if you have questions specifically about your business and how this would apply, then you're going to want to consult counsel.
Any additional questions?
Okay, so this is Jack again. Betsy, that was great, really informative. There's lots of things to be considering, particularly now as we're operating in our new environment. And we do appreciate that. We're going to summarize what we talked about here today and share it with some of our members so that they'll have additional tools that they can be using. But we really do appreciate that. That's great. Thank you. And as we mentioned earlier, please join us tomorrow for a deep dive into the CARES Act. There's lots of different component parts to that. And there'll be much more to come. So everybody continue to stay well, stay safe, and thank you very much. Okay.
Thank you, Jack.
Okay. Bye-bye.
Bye.